Bill Henshaw here again for the Constitutional Crisis Channel. And the subject matter for today I'm going to call Civil Rights Catastrophes. And try to clue you people into what this stuff really does. And you don't think about this, but give it a moment's thought. You're going to see some of the cases I'm going to tell you about and how this civil rights stuff works or doesn't work, depending on one's point of view. Now, to start out with, one of the first test cases for the Civil Rights Act of 1964 came in a case called Griggs versus Duke Power, 401 U.S. 424. And this is the case where the company had decided not to promote certain employees. Most of them happen to be black, coincidentally, as it turns out in this case, because they had some problems with reading and literacy, and they were thought not to be suitable for higher levels of management, in the company to help run the company. Well, the case gets to the Supreme Court, and it rules. I swear to God, and this set in motion a long train of abuse that's followed ever since. They ruled in this case. They flat out said there was no evidence of any intent by the company to discriminate. But it didn't matter because the statute as enacted didn't require any intent to do so. What the hell kind of a law was this? And this, by the way, wasn't a quote-unquote criminal law, but had it been enacted that way, the intent probably wouldn't have mattered there either. So what these nine old farts do is they say, well, we have to defer, to the superior judgment of those in the administrative agencies that handle cases like this and rely upon their ability to discern the intent of Congress in enacting these laws. Wait a minute. Can't do that. And they damn well know better than this, because an administrative agency, you can't go in there. This is exactly the problem we have in these traffic courts, by the way, quote-unquote courts. That's an administrative agency. You can't go in there and raise issues of constitutional law. As the California Supreme Court has said to me, albeit courtesy of the clerk of court, the questions you raise are beyond the jurisdiction of California courts as they appear to raise federal questions. That's exactly the same situation you have with administrative agencies or in arbitration cases, and we'll hear much more about that later on. Point is, they know better than this. They can't defer judgment. It's their job, their sanctimoniously self-proclaimed job in Marbury versus Madison. 5 U.S. 137. You probably heard this case when you were in school. It's only one of the two cases I ever got. That they had the power to say what the law is. Why the hell didn't they do it in this case? The case would outcome completely different. Well, the other problem we have with this is that at the same time, and there was a lot of discussion in Congress about this, about the meaning of this law, and would it be used in this way? And the good old happy warrior, Hubert Horatio Humphrey, senator from Minnesota who ran for president in 1968, made the statement that there wasn't anything in there that could be construed in that way, and he would eat each and every page that you could find that would have that kind of a definition in it. Well, that would have appeared to settle the issue, except that the first head of the Civil Rights Commission, Alfred P. Blumrosen, and the bastard's still alive today, by the way, at the age of 95, hopefully not in good health, and he flat out said that he didn't care what the intent of Congress was in enacting the statutes. He was going to interpret them in his own way to achieve the best results. That's how this case gets to the Supreme Court. And they defer to these agencies who have been instructed by Blumrosen to do exactly what they did. Who the hell cares about intent? That's not relevant here. The plain fact of the matter is that these black people were discriminated against, and that's all that's necessary. My Lord, the Pandora's box that's open, you will not believe. But this is civil rights. Now you go on to a later case you may be more familiar with, called Casey Martin versus the Professional Golfers Association. That's 10 or 12 years ago now. And the case involved Casey Martin, and he was white, by the way, but this wasn't a major issue in the case. And he wanted to be allowed to play on the PGA Tour, despite the fact that he had a handicapped left leg, so this is probably the Americans with Disabilities Act, and be allowed to use a cart to drive around the golf course. Now, if you don't know, when you play pro golf courses tend to be somewhere around 7,200 yards or longer, and walking, especially in the summer months, and most particularly in the United States Open, where the temperatures can reach into the mid-90s or higher. To have a cart, that's a hell of a big competitive advantage. Well, it gets to the Supreme Court, and they rule in favor of Casey Martin and said that he should be allowed to play, notwithstanding the fact that this big competitive edge is going to occur. Should be noted here that, and I'll check records, but as far as I know, Martin never did win anything, let alone the U.S. Open. But the problem I have with the case like this is the precedent that it sets. Because this looks like relatively minor, nothing case on its facts. But suppose down the road that you have a case where a quadriplegic in a wheelchair wants to come in and try out for quarterback for the San Francisco 49ers. Can you not use the same logic there? And by the way, I mentioned being in 2015. Hell, that might even be actually improvement over Colin Kaepernick. Story for another day. But the same reasoning, this Martin case would be precedent to do this. As ludicrous as it seems on its face, trust me, attorneys know about precedent, they know about res judicata, and some of them would not hesitate at all to do something like this if it came up or if it occurred to them. Now you get on to some more controversial type things, and you notice in this day and age, with the NFL and the NBA, and what goes on, and you look at all the players on the teams, and they show you at the start of the game with the football games, they outline all the players. Out of 22 players, you're going to notice on the average, probably 19, maybe 20 of them are black. 2 of them are white. Well, wait a minute. That's reverse discrimination, is it not? Because businesses are told they have to have a certain percentage of the population, in their given areas to reflect the population of the area fairly and equitably. It would seem to me if that's the case, then the same rules would have to apply to the NFL and the NBA and others, because they're every bit of a business, just as they are at the San Francisco airport, for example. What's the difference here? So, by the way, the bottom line with these civil rights cases, as bad as it is, equality of opportunity, what they want is equality of result, notwithstanding. And this, by the way, is at the center of another case you may have heard of called Alan Bakke versus the Regents of the University of California. This goes back a number of years, and he was complaining that he was not admitted into the UC Davis Law School, the medical school, because his scores were lower than some of the black applicants who were admitted. But these black applicants had the luxury of having points added to their score to make up for past discrimination. Bear in mind, this is about 1975, this case, so we hadn't had any slaves around here for close to 100 years. And this also arose in a case that I don't have off the top of my head with firefighters in New York City that went through the same thing with all these favorable things, trying to make up for past, atone for past sins. And Bakke did win the case, and he was white, by the way. Again, he was white, and this was mentioned in the case, but there were no issues arising under the organic constitution here. He used Title 42 U.S.C. 1983, and that was the extent of it. There was never any challenge to any of that. So therefore, when I get into court and bring my own case, if they're going to try to use that against me or you as precedent, doesn't apply. The Supreme Court, by their own rules, knows it doesn't apply. But these are the kind of things, that it's just inconceivable how these things can be interpreted. And yet, especially in the context of pro sports or even college sports, it just gets ludicrous. For example, you get so bad that you could have the functional equivalent of Danny DeVito wanting to try out to be a defensive lineman for the Chicago Bears. That's how ludicrous it is. But it could happen, all of it, because the precedent is there under these civil rights statutes, which even if they had any constitutional pedigree at all, couldn't be interpreted in that way, one would assume, unless you understand my issue of state versus territory. That's how they're doing it. Because in the body of the state, none of these laws would have any application whatsoever. Washington, D.C., yes. Federal enclaves, probably. That's like federal military installations and things like that, probably. Insular territories like Guam, Puerto Rico, the Philippines, very probably would apply. In states, no. Because those are the original sovereign states, and they were the ones that created the whole government. And it makes zero sense to now have the government completely in control of each and every function of the state government and of the lives of all the state citizens based on civil rights acts or any other acts of legislation that invade the province and the sovereignty of the states. That's the problem with all this. And at the end of this video, I'm going to invite any advocate of civil rights who wants to take me on to come and do it. And I'll do so a cappella, and I'll lick my chops to get a chance like that. It's just not, my goodness. So you Al Sharptons and Jesse Jacksons, why don't you show up and try to tell me that I'm wrong? I'd love to see it. It's been 4 decades. I have yet to see any evidence whatsoever that I'm out in left field here. So that said, we'll have a follow-up on this one later as events develop too. Now, continuing the video, on using civil rights statutes in the context of professional sports. First thing I should say is I'm not accusing anybody here of doing anything wrong, most particularly Casey Martin. I don't have that in mind at all. It's just that the situation that arose from that and other suits that may have followed because of it, that's what's wrong. I mean, sports are what they are, and you can't take away from that. If you do that and you take away from the competitive advantage that really good players would have in whatever sport it is. And I was just thinking about the U.S. Open, by the way, where I said, for example, with Casey Martin and a cart, on a really hot day, and this is played in June and July, and it's often in the 90s, if not 3 digits, that's effectively giving him maybe a stroke and a half a round, which is 6 strokes for the whole tournament. And on day one, if you know that going in and you're another talented player, you realize you're going to have to take more chances in order to overcome that early lead, and probably end up taking more bogeys and losing more strokes because of it, where Casey Martin wouldn't have to do that. Just the opposite. He could play it somewhat closer to the best and only take the occasional chance, knowing the comfy lead he had going in. That's the kind of disparity that simply can't exist in professional sports or even college sports or what have you. It's not how sports are designed to work. And for that reason, civil rights should have had nothing to do with it. I mean, I'm embarrassed the Supreme Court made a decision like that, but it's in the books. Who knows what it'll be used for next? We'll just see about that. If something comes up in the future about that, we're going to have an update to this video. Thank you.